Mr. Rodriguez, if you'll come down, if I could have parties announced for the record for the state.
Robert Robot for Noel Rodriguez.
And are you Mr. Rodriguez? All right, you entered a no contest plea on October 16, 2024 to the offense of choking. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. The state opposes your application. They're taking in consideration 2024 CR 008862. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, ma'am.
Any objections to the PSI report, state?
No objection.
No
Defense?
objections, Your Honor.
Have both parties had a chance to review the TAP evaluation, state?
Yes.
Defense?
Yes, ma'am.
Any objection to the TAP evaluation, state?
No objection.
Defense?
No objections.
Any witnesses, state?
No witnesses, Judge.
Defense, any witnesses?
No, ma'am.
All right. I'll hear argument then. State, you're opposed?
We are, Judge. Given the defendant's criminal history, this is not the first felony that he's been committed or that's been convicted of.
The prosecutor opens by pointing to the defendant's criminal history. But what he's about to reveal is that this isn't just a history of crime. It's a history of violence.
He has committed multiple acts of family violence, and one in October of 2023 was a choking and strangulation. However, that case was dismissed because the complainant waived prosecution.
And who was the complainant in that case?
It would have to check, actually, Judge. He has been convicted of an unlawful carry of weapon and assault in 2021, and I can check the victim on that one momentarily. He also has been convicted out of state, out of Wilson County, for an assault second. He was given probation in that case. However, he did not complete his probation. He was revoked on December of 2023.
This is devastating for the defense. The defendant was already on probation for assault, and he failed. He had his chance, and he blew it. But the prosecutor isn't even close to finished. He has one more piece of evidence that is so shocking, it changes the entire hearing.
And he is pleading to one case, which is the offense date of the 6th of June of 2024. It wasn't until he bonded out 3 days later, he committed another offense on June the 9th of 2024, also an assault second. Given his criminal history, given the fact that he has been given an opportunity to get probation in Wilson County and has been revoked, the state does not believe he would be a good candidate for probation, and we ask that you sentence him to no more than 10 years TBC.
This is the final nail in the coffin. The man in this video, Noel Rodriguez, is in court for a violent assault on June 6th. He gets out on bond, and just 3 days later, he allegedly does it again. Now, the defense has to do something, and they pull out a trump card nobody was expecting.
Right. And while the state is finding the list of the complainant on the other cases, defense, I'll hear your argument.
Yes, Judge, the defendant's been in custody for 168 days. He has no felony convictions that I know of. He has 2 children. He does need some mental health assessment. The complainant in the case, Megan Rodriguez, in the report states that she's in favor of probation. I think with the proper guidelines set forth and conditions that the probation recommends that he's learned his lesson. He's taken anger management courses, 12 of them. I'd like to give you copies
Any
of those.
objection to the court reviewing the certificates?
Okay.
This is a massive twist. The victim, the woman he's convicted of choking, wants him back. The defense sees an opening, arguing he's a father of 2 who's even taken anger management classes. But the judge looks skeptical. What does the victim know that the prosecutor doesn't? Or what does the prosecutor know that the victim is ignoring?
So he has spent his 168 days productively in custody, and he's ready to return. He has to support his 2 children, needs to get back to work. And I think that any other conditions that you might give him that are outlined in the probation report, he's willing to follow your rules and not come back here.
All right, defense. I'm sorry, state.
To answer your previous questions on the first assault, the misdemeanor conviction was a different complainant. on the assault, choking strangulation that occurred on October 26th of 2023, where the case was dismissed for complaining waiving prosecution, was the same complainant as this case. It has a different last name, but I confirm it's the same date of birth.
All right. And then the case that you're taking in consideration, the ABI second, who's the complainant?
That one should also be the same.
All right. Is there anything you wish to say?
I'm very more.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record. All right. So what was this argument about?
I can't even remember that day.
All right. Because according to the stipulations, it states that the complainant was sick through food poisoning, and she asked for your help caring for your child, which was crying. And it says that you became angry with her. So she ended up taking the child and asked you to fix a bottle for the baby. You were still angry and you were upset with her requests. So she put the child down and went to get the bottle for herself. You wanted to leave the residence and tried to get the car keys. She would not give you the car keys, so you slapped her. She defended herself. You hit her in her chest, then placed your hands around her neck, choking her. So you don't remember any of that?
No, Your Honor. I was putting my daughter to sleep that night, and she had been in the restroom. I was having difficulty putting my daughter to sleep, and I had asked her to help me. She ended up picking up our daughter, and she started rocking her, putting her to sleep after that. I was frustrated, but I wasn't trying to leave at that point. It wasn't until she had started getting physical that I was trying to leave. But at no point did...
He just told the judge he can't even remember what happened. So the judge decides to read the official police report to him, and the details of what he did to the mother of his children are absolutely brutal.
Well, it says here, the victim stated that she was strangled by her boyfriend. She sustained injuries to her neck and chest. While speaking with the victim, I observed scratch marks and redness to the left and right side of the neck and redness to the chest. I observed bruising to the left and right biceps and underneath both arms of the victim. And they photographed the injuries. I also photographed a large amount of black curly hair clippings that were in the bathroom allegedly left by the suspect prior to him fleeing the location.
I had cut my hair that day.
All right. Well, in the report, they make it seem as though you choked her and then you cut your hair and then you left.
The judge corners him. The police report doesn't just describe the choking, it describes him cutting his hair to change his appearance before he fled the scene. He's denied it all, but he's about to make a fatal mistake and change his story.
That day, it's hard to recall that day, but I know that when she had started choking me, and
Oh, so you're saying she started choking you first?
yes, ma'am.
Okay. You may continue.
After that I started going back at her, and I regret it deeply. It's just...
Okay. All right. Any questions?
No, Your Honor.
State any questions.
Just a couple, Your Honor. Mr. Rodriguez, you are applying for probation, or you're asking the court for probation. Okay. So you understand that the first step of probation is accepting responsibility, right? But when you spoke with the probation officer when this report was being prepared, you did not want to talk about the incident, right?
I told the probation officer that I couldn't recall it fully.
Okay. So you did say that you had difficulty remembering, but then you also said that you'd rather not talk about
I didn't want to talk about it without remembering it fully.
Okay. But you do remember that she started it?
Yes, sir.
Okay. How is that accepting responsibility if you're blaming it on her?
He's trapped. The prosecutor just caught him in a massive contradiction. He told the judge he's taking responsibility for his actions, right after blaming the entire thing on the woman he choked. The judge has heard both sides, and now it's time for the sentence.
Oh, I'm taking responsibility for my actions. I shouldn't have reacted the way that I did. I should have just walked out of the house once things started getting physical.
But you understand that you've been placed on probation before, right?
Yes.
And the idea is probation should give you the opportunity to rehabilitate yourself and avoid engaging in any more criminal behavior, right?
Yes, sir.
So you didn't complete probation in Wilson County, right?
No, sir.
Okay, and then you committed an offense on June the 6th, right? Of 2024? The choking?
Yes, sir.
And then again on June the 9th of 2024, right?
Yes, sir. Or June 9th, that day I didn't really do anything. I had OD and my wife had called the cops saying that she needed an ambulance for me.
No further questions, Judge.
All right. Anything else from the
No,
defense?
I think, Judge, the fact that he took these anger management courses shows that he wants to comply with the terms of probation if you give it to him.
All right. The court is going to deny your application, find you guilty. Does anyone wish to speak to the cap?
Judge, in light of the fact that he has two children, and he has a household that needs him, we request the cap be the minimum of 2 years.
All right. State, what are you requesting?
That's no more than 10 years.
All right. Mr. Rodriguez, I want you to know that I listened to the arguments of both sides. I listened to your testimony. I read the stipulations again because I'm not the one who accepted this plea. And I also reviewed the TAP evaluation and I reviewed the PSI report. This is what the court is going to do. Court is finding you guilty. There's an affirmative finding of family violence. The court will give you credit for any time served. Taking consideration 2024 CR 008862, there's to be no contact with Megan Lindsay Garza, no unsupervised contacts with minors. I'll recommend the therapeutic community for you. The therapeutic community does not increase the amount of time that you serve. For example, if I were to send you to 10 years, the fact that you're in the therapeutic community will not extend you beyond my sentence. Do you understand?
Yes, sir.
I do not have jurisdiction to force them to place you in the therapeutic community, so you'll have to request it. But it will show in your judgment that the court is requesting the therapeutic community for you to address any drug or alcohol issue or any mental health issues. And the court will sentence you to 6 years in the prison. Did you review the document? Yes?
Would it be possible
Yeah.
to get the no contact order dropped?
No.
The judge shuts him down instantly. He's just been sentenced to 6 years for choking his partner, and his first question is if he can see her again. The judge is not just sentencing him for his crime, she is intervening, and her reason why is chilling.
And let me explain to you why. I don't like for people to think that I just do things just to do things. For example, because it's 6 years instead of 10, there's a reason for that. I took in consideration the mitigation evidence. I took into consideration what the complainant wanted, and I took into consideration your criminal history, and I took into consideration the classes that you completed. With regards to the no contact order, there's an issue here, and that issue hasn't been solved because this is not the first time that you were accused of assaulting her. This is the first time that I guess she's given a statement to the police about it and come to court about it and continued with it. So obviously that relationship is not working. I don't have you on supervision with the court because I'm sending you to prison. If I had you on supervision, I would still have the no contact order, then maybe slowly consider lifting the no contact order. But not in this case, the answer will be no. All right, so that's 6 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
You signed.
Yes, Your
All
Honor.
right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I know 6 years is a lot of time. It's a lot of time away from your children, but you can't continue to commit actions that you commit, violent actions, and then not expect there to be any consequences. When you're released from prison, if I'm still here, you need to make sure that you take care of your drug issues and you take care of your mental health issues. If you cannot find a place, come back here and I will pick up the phone and call someone to help you. You understand?
Upon my release, I plan on going to CHCS, Center for Healthcare Services.
Okay, that's great.
Get my primary care doctor back on.